Today I'm going to be talking about the 5 reasons why one defendant might get a better outcome than another defendant in a criminal case. My name is Veronica. I am a criminal defense attorney here in California, and I help people who have been arrested put their criminal cases behind them so that they can enjoy their lives and their freedom. And again, in this video, I am going to be discussing the 5 reasons why one defendant might get a better outcome than another defendant in a criminal case. And I'm going to make another video on why an attorney might get better offers for their clients and better outcomes for their clients in criminal cases. But for this one, I'm just going to be sticking to the defendant. So if you're thinking, yeah, but what about the attorney? That makes a big difference. You are absolutely correct, but watch my other video. Okay, so number 1 is the strength and severity of the evidence. So when I say strength of the evidence, okay, did they just have witness statements? Is this a he said, she said sort of thing? Or do they have someone on video? If they have someone on video, can you clearly see that it's you or the defendant and clearly see their face? What else do they have? Is there forensic evidence? Depending on the type of case, they may not have bothered to collect that. I've had attempted murder cases where they didn't bother to collect it. But what do they have on you, right? So that's number 1. Number 2 is the availability of defenses and motions. So sometimes maybe you have been diagnosed with bipolar disorder and you were diagnosed with that a long time ago, and you've been trying to get the right cocktail of medications, but you really haven't found the right combination. Maybe you were off your meds and this happened. Okay, maybe we can file a mental health diversion motion in that case. Or maybe the main evidence against you is that you confessed, but you were in custody. So you were at least arrested, restrained from movement. A reasonable person in your position would not have felt free to leave. And they were asking you questions. Okay, well now we're going to file a motion to suppress evidence. And if that motion is successful, then the entire case would be dismissed if that's the only evidence. But even before that, if you're like, well, I'm not sure if it's going to be successful or not. Maybe it's not clear if a reasonable person in your position would have felt free to leave. Well, you can at least use that leverage that you have. Your attorney can either file the motion, talk to the prosecutor, say they're filing the motion, and then see when they talk to the DA, what kind of headway they're able to get using that as leverage for you. Number 3 is, unfortunately, the DA assigns your case and their personal feelings. So especially if you have the misfortune of having a specially assigned DA, this is very frequent. So the specially assigned DAs, okay, so there are general DAs who they go into a specific courtroom every day. The DA is the prosecutor. They go into a specific courtroom every day and they're in charge of whatever may come in. So it could be, usually they're all misdemeanors or all felonies, but whatever comes in there, any type of case, doesn't matter what it is. It could be a gang case, bar fight, domestic violence, DUI, doesn't really matter. They're handling them all. But then there are specially assigned DAs. So, the one that's the most pleased with itself in Los Angeles used to be the hardcore gang division. Now I think they're called the community violence prevention or something. Gascon sort of took their wings away from them there a little bit, which is, I think, really freaking funny because they were so proud to be called hardcore. But these are people who they absolutely, their life's mission, or at least at this time, is to take gang members and get them off the streets. So if I'm saying, hey, my client's a gang member, but you know what, he's actually a good guy, please put him back on the street. They don't want to do that. That's the opposite of what they're trying to do. But even worse than that, I like to make fun of those guys a little bit. But even worse than that are the sex crimes, especially assigned DAs, or domestic violence or family violence prevention unit that they have in Los Angeles here. And it's the same throughout the state where they have these specially assigned DAs. That can be really bad because this is a DA who has decided for whatever reason that they want to prosecute everybody who's involved in sex crimes. So many times, maybe something happened to them or somebody that they love. Same with domestic violence, family violence. So they feel really, really strongly about these cases, and they are going to potentially be less likely to give you a good deal. So there could be maybe you at your courthouse, you end up with one of these specially assigned DAs, your friend who is accused of pretty much the same kind of thing, has pretty much the same criminal history or background. is at a different courthouse, has a regular DA who doesn't really particularly care about their case type, they may get a better deal than you, all else being equal. Number 4 is following your attorney's advice. Now, I'm not saying blindly follow your attorney's advice. If you don't like your attorney, get a different attorney. If you have a public defender and you really don't like them, it's worth it. Get a private attorney. If you don't like your private attorney, get a different private attorney, or at least get a second opinion on your case. But I'll tell clients sometimes, okay, I need you to start taking these classes. I need you to start taking therapy. I need you to stop doing something that you're doing, posting on social media about the case, sadly enough. Whatever it is, it's important to follow that advice. So again, if you don't trust it, get rid of that attorney. But if you have an attorney, this is your only friend in the courtroom. This is the person who is trying to get you, hopefully, the best possible outcome in your case. Number 5 is understanding what is at stake and the likelihood of success if the case were to go to trial. So again, you should be listening to your attorney. If you don't understand what they're saying, then ask them questions. Make sure you understand. But you need to understand, what is the worst that could happen in this case if I go to trial and lose? That's really important, even if you don't want to go to trial, because all throughout the criminal case, everyone is thinking about this. All the attorneys, the judge. Okay, if we were to go to trial, how likely is it that the prosecution would win? How likely is it that the defense would win? That's where your bargaining power is. So you need to understand, okay, first of all, worst that could happen, is it prison time? If so, how much? How much would I likely get? Most people, if it's like their first offense, you're unlikely to get the max. But what's the worst that could happen? And then how likely is that to happen? And then how strong really is your case? So you should ask your attorney these questions and ask them, what's the worst evidence against me? Do you think that we would win this at trial or not? And they should be able to give you an opinion on that. And then I'm going to give you a bonus one because I forgot to include it, because to me it's in every criminal case, but you might not necessarily know that. The last one is criminal history. So I've had clients who are in jail and they are awaiting trial or resolution of the case. They talk to other people in jail, and that's actually about all of these things. They'll hear from a friend that guy's friend maybe got probation on an attempted murder case, and they're like, hey, why don't I have probation? I should have that offer, which goes back to number 5. But a big thing there is going to be criminal history. One thing that I ask them then is, well, what was that guy's criminal history? What was the evidence against him? These are all questions, but criminal history is really big. And if I have like a third strike client, it's going to be a lot harder to get him a good deal on his third strike than it was on the first strike. Not always, though. I mean, all of these factors are important. And I recently had a third strike client who, for a while, they were saying it's going to be double digits. And ultimately, he did get 4 years. That was a matter of being persistent. And that particular client was really good at understanding what was at stake, at following my instructions so that he could get the best possible result and make good decisions for his case pretty quickly. I hope that you found this video helpful. If you do have a criminal case in California, feel free to give me a call. You can find my number down below. You can also click on the link there to book a consultation with me.